Welcome to the Dummy Kruger channel, everyone. Today, we're going to be doing a deep dive into Denver Metro Audit's guilty verdict stemming from an incident that took place in August of 2022. We are first going to be looking into the background of the case, followed up by some of the presumed arguments DMA made during his trial, and finally ending with going over parts of the judge's verdict. I say presumed arguments because, at this present time, I can only go off the available court documents, which include DMA's motion to dismiss, the U.S.'s opposition to the motion to dismiss, and what the judge wrote while explaining his verdict. However, I have requested the audio transcript for the trial, so if/when it is available, I'll be bringing it to my audience forthwith. Let's first take a look at the background of the case, intertwined with what was seemingly the U.S.'s biggest piece of evidence, DMA's own recording. On August 2, 2022, Cordova arrived at the SSA office in Littleton at approximately 11:54 a.m. to record inside the office. Security officers immediately informed him he could not record video inside the SSA space because customers had personal information like social security numbers in the open. Around the same time, Cordova began live streaming video from his phone to a public YouTube channel. He stated to his audience that he intended to live stream from inside the SSA office to, quote, exercise a First Amendment protected right. See Denver Metro Audit's YouTube video.
See, now they're denying people service. Sorry about that, ma'am. So they're denying people to come in now because we're here exercising a First Amendment protected right. So this is crazy, guys. For coming in, I'm here, of course, with Sweet Tea, guys. So make sure that you support her too. So like and subscribe on hers.
He predicted that the day would end in one of two ways. Quote, we'll be allowed to be let in, or we are all leaving in handcuffs.
So we got one of two things that's gonna happen, guys. Either A, the cops are gonna come and tell them there's nothing they can do. There's no law. And number two, they're going to arrest us. And then we will have civil litigation, I guess. So one of those two things are gonna happen, guys. That's it. We're either gonna be allowed to be let in, or we're leaving in handcuffs. So stay tuned to see what happened.
Cordova acknowledged that officers told him, quote, we are not allowed to record in there, but asserted that he would do so anyway. Quote, we're about ready to just mob right in there right now.
We're outside the Social Security office. Security guard already came out hollering that we're not allowed to record in there. So I just said, okay, because I don't want him to block us from coming in, but me and Sweet Tea, come on. We're about ready to just mob right in there right now.
He was shown signs posted to the exterior and interior doors prohibiting his entry, but stated that he need not follow them. Quote, that's just a piece of paper. That's not a law.
This guy said he's calling the police on me because I'm recording him.
About what we're talking about? There is this right here, okay?
Let me see, let me get a shot of that.
Personal electronic devices may not be used to take photographs or make video recordings.
That's not a CFR though. Yes, that's just a piece of paper. Anyone can write, you could write no red shirts.
And you're still doing it.
That's not a law, sir. That's just a piece of paper.
This is posted by the Social Security Administration.
That's not a law. It's not a law, sir.
He was told he could enter the SSA space to get brochures and talk to SSA representatives so long as he did not record inside.
So hopefully it doesn't come to that.
We wanted to get some of these brochures that were in here. I needed to get some for the people that I work with, and I'm being refused. I just wanted to show documenting that I'm getting those brochures.
Oh, I want you to have those brochures. However, you cannot take that camera and record inside this facility. That won't happen.
So I can take my phone in though, right? Because everybody else has their phones.
As long as you're not recording.
Yeah, that's not true, sir. That's not true.
That is true, and this isn't the time and place to argue it. I'm telling you right now that I am not going to allow you to film beyond this door.
Indeed, during the live stream, Cordova stated multiple times that officers told him he could not film inside the SSA's interior space.
Instantly, this guy Chavez, right there, security guard, came out hollering orders at us that this is federal property, we can't record in here. You guys can record outside, he said. So I said, okay, fine, that's cool. And so, because I didn't want him to block us from coming in, so then I said, that's fine. And then I went live because I already knew it was gonna be a crazy video. Walked in.
He also zoomed in and read aloud for his live stream viewers the official signs that prohibited photography while inside the SSA offices, which included signs posted to the exterior and interior doors, as seen here. He was also given a paper copy of 41 CFR with the language prohibiting photography inside space occupied by a federal executive agency highlighted. An officer further explained to Cordova that the regulation prevented him from filming in the space occupied by the SSA.
Anyway, I'm going to give you a copy of the CFR, the Code of Federal Regulations, that talks about where you can film and where you can't, and when you need the tenant's permission and when you don't. I'm going to give you guys a copy of that, so you have it for your reference today and moving forward. Also, the secure space in this building starts at that door, okay? It's not this door. This is just kind of I guess an air conditioning buffer, if you will, like a climate control buffer. The actual controlled space for this facility starts at that door. That's the door that locks it up, okay? So this sign applies to this area. I have spoken with the facility manager, and he is perfectly okay with you guys could be compromised, for people's personal business or PII information that could be compromised by you guys being in the lobby. And we're okay with that. If you guys want to stay out here, we're not going to give you a hard time at all. You can stay here till they close. Don't care. Okay? The problem we'll have is if you try to come inside where you can hear conversations taking place and potentially see information. Okay? So here, we're not going to bother you a bit.
Can I get your name, inspector? What's your name and
My
badge
name
number?
is Doug Wiles. I'm the commander for this area,
Okay.
and my badge number is 889.
Do you have a business card?
Sadly, I don't, but I'll give you that information. I usually do have a business card, but I just put it in a backpack on a plane I got out of COVID. Forgot to take them out and put them in my pocket.
So I got a question for you. Did you swear an oath to the Constitution when you took your job as an inspector at the DHS? So are you going to honor your oath then? Because preventing us from coming in here is not honoring your oath.
No, you can come in here if you have business.
I do have business. I do have business to conduct.
Come in here and record.
Yes, I can.
That's specific with
Yes, I can come in here and record.
across the country.
I can come in here and record. According to the 2018 memo, sir, I just gave you the law.
According to that sign right here in the law that I'm trying to give you, but you're refusing.
No.
to take,
This is not a law.
sign-
That is a sign that has no
sign
law.
is referencing this document. Now, if you choose not to take it, that's fine with me, but.
I'll take it.
There you go. It is prohibited.
At approximately 3 p.m., Cordova walked from the entryway where he had been filming for approximately 3 hours through the interior door to the SSA office. Before he entered, he said, "I already told him we are going in, guys. We are going in. If they want to cite me or arrest me or whatever, that's what's going to happen. But we are going in."
That's why I came, in case you got taken
Well,
down.
now he's back on the phone, guys. He's back on the phone. So,
I can zoom in on
I already told him we're going in, guys. We're going in. As soon as, if they want to cite me or arrest me or whatever, that's what's going to happen, but we're going in.
If they do, I will sue him first, because he's in charge. You're in charge, right?
So that was, of course, Chili DeCastro, aka Delete Laws. Chili showed up on the scene a couple hours into their live stream as, quote, backup. You can hear Chili threatening to sue more officers, but what's really funny is a couple of days later, Chili actually threatens to sue DMA for what he referred to as slander when an argument broke out about super chats. Continuing with more background, it's written, as he began to live stream his entrance, he asked rhetorically, "Should I go in? Here I go, guys," as he was told by a friend that, quote, "They are going to arrest you now, get ready." And that friend was Chili DeCastro.
So are you just staying here now for personal security to keep us from coming? You're walking away? Okay, because when you leave, we're going to go in here.
You mad? You mad as shit. You mad as shit, boy. Yeah, walk your shame. Walk your bitch ass on in the back.
Okay, should I go in?
You think so?
Here I go, guys.
Great.
They're gonna arrest you, man. Ready?
There you go.
You're now under arrest.
What are you arresting
You're
for?
now under arrest.
They're arresting
I'm under arrest, guys.
Come back here.
I'm under arrest.
Come back
Keep
here.
rolling, keep rolling
Come
your
back
film.
here.
Keep rolling your film. They're arresting.
Come back here.
I'm under arrest, guys.
So DMA had a couple of main arguments, but one of his biggest ones was that the entire law was actually unconstitutional on the grounds that it was a violation of the First Amendment. It reads, Cordova argues that 41 CFR 102-74-420 violates the First Amendment on its face. In support, he offers only one single argument, that the regulation is unreasonable because the purpose served by a regulation applying to multiple federal executive agencies is, quote, unclear, when agencies, quote, may be wildly different. His argument ignores the purpose of the GSA regulations he is challenging, which unambiguously specify a reasonable purpose of ensuring agencies can fulfill the missions and objectives they are legally obligated to perform. Cordova ignores the text and context of this regulation when he concludes that its purpose is unclear. The purpose of the photography restriction is to ensure that federal agencies can provide services consistent with their operational needs and accomplish overall government objectives. It continues, simply put, Cordova's actions were not compatible with the intended purpose of the property as a space for the SSA to fulfill the agency's mission. There was also an argument about non-public forums versus traditional public forums. It reads, government restrictions on speech in non-public forum need only be viewpoint neutral and reasonable in light of the forum's purpose. Interestingly, both the government and DMA's side agree the SSA offices are a non-public forum, but that didn't stop DMA's attorney from quoting case law that involved only traditional public forums. The government writes, Cordova's reliance on cases discussing video recording as a form of speech creation is misplaced. These cases relate to recording video in a public forum. The government does not dispute that video recording is afforded some protection under the First Amendment, as are other activities prohibited in federal agency offices by the GSA regulations, such as solicitation, posting flyers, and commercial advertising. It seems they are essentially saying, yes, video recording can be protected under the First Amendment, but so are these other First Amendment activities like solicitation and posting flyers. From my understanding, as long as these prohibitions are viewpoint neutral in a non-public forum, those prohibitions on First Amendment activities are lawful. They close out their argument saying the following. The narrow question here, however, is whether Cordova had a right to exercise that right in a non-public forum in which the GSA imposed a reasonable restriction to help federal executive agencies meet their operational needs and efficiently use taxpayer dollars. He did not. Another one of DMA's argument to dismiss was that the law was vague. Let's jump into that. They argue, so long as the defendant had fair notice that the particular conduct which he engaged in was punishable, the court must reject his vagueness challenge. The regulation gave Cordova fair notice that his conduct was punishable. First, the opening clause of the regulation makes clear that photographs may be taken only where not prohibited by security regulations, rules, orders, or directives. Continuing, and officers stationed in the SSA space verbally gave Cordova a security order that he could not take the photographs inside. This posted sign and verbal order are sufficient to defeat any vagueness as it applies in his own case. Not only that, they continue arguing, saying second, even absent a security directive or order, the regulation plainly states that persons cannot take photographs in space occupied by a federal agency without that agency's permission. And then they hammer it home. It says, finally, Cordova's own words defeat his vagueness challenge. Immediately prior to filming inside the SSA space, he announced on his live stream that filming inside was punishable by arrest or ticket. His voidness claim, which depends on him not knowing his conduct was punishable, contradicts his frequent admission during the video he live streamed that he knew his conduct was punishable. The irony of the US using DMA's own YouTube video to not only show he committed the crime, but that he also tanked his own defense through his monologue is certainly not lost on me. So that was the meat of the opposition to dismiss. Shortly after both motions were submitted, the judge denied DMA's motion to dismiss. The one-day bench trial took place on March 16th of this year and would last about 2.5 hours. The U.S. would call 2 FPS officers to testify, while DMA himself took the stand in his own defense. A few exhibits were allowed, including DMA's YouTube video and Sweet T's YouTube video. I'm going to go over a few of the parts of the verdict that gives us some insight into what DMA and his attorney attempted to argue. I'm unsure if he argued more about the non-public forum versus traditional public forum from his motion to dismiss or not. I'm leaning he no longer used those arguments during his trial, as the judge didn't mention anything about them. The basis of his argument seems to be mostly about the meaning of words in the statute he was charged with, in particular, what a lobby means. In terms of deciphering what the regulation actually means, The judge writes, I should assume that the ordinary meaning of the regulation's language expresses its purpose and enforce according to its terms. When called on to resolve a dispute over a law's meaning, this court normally seeks to afford the law's terms their ordinary meaning. The judge continues, finally, both the Supreme Court and the Tenth Circuit commonly rely on an ordinary dictionary to ascertain the meaning of a law's wording. Surprisingly enough, they use the Merriam-Webster dictionary, not Black's Law Dictionary. So he focuses on count 1 first. From what I can tell, DMA's lawyer didn't really argue count 1 whatsoever. I think what he may have argued was count 2 was vague, thus making it unconstitutional, and if count 2 was to be found unconstitutional, count 1 wouldn't exist either. First he goes over the statute. Persons in and on property must at all times comply with official signs of prohibitory, regulatory, or directory nature and with the lawful direction of federal police officers and other authorized individuals. The judge continues, based on my analysis of count 2, I find beyond a reasonable doubt that the SSA law enforcement officers gave Mr. Cordova lawful directions to not film in the SSA interior office and warned him that he would be arrested if he did, yet Mr. Cordova failed to comply. He also failed to comply with official signs. He finishes count 1's argument off with, incidentally, unlike the language in the following regulation under count 2, Mr. Cordova does not challenge the meaning of these words. So the judge quickly moves on to count 2, writing, count 2 alleges Mr. Cordova violated 41 CFR, which prohibits photographing in spaces occupied by a tenant agency without permission of the occupying agency. So that covered the first 2 subsections in this statute. But in regards to the third subsection, he writes, it does permit photographing in building entrances, lobbies, foyers, corridors, and auditoriums for news purposes. This next line I actually found quite interesting. He writes, I accept Mr. Cordova was filming for news purposes. I've made the mostly unpopular argument in a few of my videos that I don't really care that they call themselves journalists. I think most of them are delusional for the most part, so let them call themselves whatever they like. I can, however, understand that actual journalists may be annoyed that they represent themselves as journalists. I've also made the argument, once again being an unpopular one, that it's tricky to define what news actually is. Who's the arbiter of what makes something news and what doesn't? Now, after watching these auditors for quite some time now, I understand that they are there to provoke a reaction, no matter how much they refuse to own up to it. Recently, the YouTube channel Tones Overthinks It put out a video showing that Denver Metro Audits himself doesn't even consider himself news. He's just an entertainer.
Let's focus mainly on the one he was addressing, option C, if it's for news purposes. This is apparently the gotcha moment that they all use to say, well, we don't have to ask for permission to do what we're doing because we're journalists and we're doing this for news purposes. Did you know that Google Chrome has this fun little feature where if you press F12, it opens up the web inspector and debugger? And if you navigate to a little something called sources, it will show you the code for the entire page. Now, why do this? Well, apparently, whenever someone uploads a video to YouTube, they have to select a category. So this means that content creators have the ability to designate what purpose their content is for. You following me so far? Perfect. Now let's go back to the web inspector and debugger. Again, F12. Navigate to source. Once you're seeing the code, hit Ctrl F and search for category. You'll have 3 results. Simply go down to the third one and you will see what category the content creator chose when they uploaded the video. And my, what is this? The category DMA chose when he uploaded this footage is entertainment. An interesting choice out of the 15 options, considering 2 of those options happen to be news and activism.
After watching Tones' video about how they categorize themselves as entertainment rather than news, I've come to the realization that maybe I was underthinking it. Back to the verdict, the judge writes, so is Mr. Cordova in a space occupied by the SSA, or was he filming in a subsection C space at the time he was arrested? First, he uses the Merriam-Webster dictionary to define what the words in the statute actually mean. The judge continues, under all the interpretation rules and methods described above, I do not hesitate to ascribe to the first 4 of these a meaning that encompasses the first space into which Mr. Cordova entered on August 2nd, the glassed entry space where, logically, persons seeking to do business with the SSA would collect themselves, wipe their feet off, brush off snow, or otherwise prepare to enter the SSA office. No SSA business would logically occur in this space, nor did any occur during the hours of filming. What the judge is saying here is that the first area DMA was in, Per how the statute is written, he had a right to film in, and the officers on scene agreed with him letting him film there for 3+ hours. But, on the other hand, through that interior second set of doors, the SSA conducted its primary business of assisting the public. During Mr. Cordova's filming, members of the public, including children, were indeed conducting business there. People were in chairs waiting for their turn. A customer check-in kiosk with a video screen was there, along with other indicia of a typical office setting. The judge is plainly saying here, as soon as he walked through that second set of doors, he was actually breaking the statute, resulting in his arrest. So the judge finally concludes, Mr. Cordova argues that 41 CFR is unconstitutionally vague in employing the terms defined above. He contends that the area in which he was arrested could reasonably be included within the subsection C. I disagree under the facts and circumstances of this case. The facts established Mr. Cordova knew the SSA and its law enforcement officials interpreted the law as prohibiting filming inside the second set of interior doors where the SSA was conducting business with its customers. He had fair notice of the language of the regulation and that his conduct would be punishable under the government's interpretation of it. Granted, he had a philosophical disagreement with that interpretation, for which he was prepared to, and in fact expected to, be arrested. Although I respect his right to challenge the law and test his constitutional rights to their outer limit, he is wrong in this instance. So, the judge found him guilty on both counts. A couple of days later, after news broke of his conviction, it was confirmed by DMA and Sweet Tea that his main argument was the definition of a lobby.
So building entrances, lobbies, foyers, corridors, or auditoriums for news purposes. So what the judge is saying, he's trying to say that he believes that the area that I entered is not a lobby. It's not a lobby. It's a space occupied by a tenant agency. That's what he's saying, because they are doing business in there. Okay. And what I'm saying is that that's just absolutely not true.
I just love when a good old nope defense makes an appearance.
Well, you know the old expression, nope.
Following that, he informs his followers that he will be appealing this straight to the Supreme Court?
So we had a trial last week, and it was a bench trial. So just let everyone know right out the gate, we are appealing it, so don't worry. We believe that we were not breaking the law. We believe that we were following the law. And so we think we have a good chance of winning in the appeal process. So my attorney is going to be filing the appeal right after sentencing. So whatever sentence he gives, it's just going to be put on hold anyways. So we'll see what happens though. Now, I believe that because it was a bench trial, these are misdemeanor charges that we don't get to go to district court. It's going to go straight to the Supreme Court. So we lose one of those appeals. So I think it's going straight to the Supreme Court now.
I couldn't locate any reference where a verdict from a U.S. District Court goes straight to the Supreme Court on appeal. I did find multiple references that say, for misdemeanor cases heard by federal magistrates, the first appeal is to a district judge in the same courthouse who will decide if the magistrate made any errors of law requiring reversal. Those of you who are smarter than I am are encouraged to comment below if they know otherwise. Lastly, I want to briefly go over the following comments the DMA made during his live stream.
I think that we have a good chance of winning, okay? But let's say that I don't win, okay? Remember, I believe that I am not breaking the law, okay? That's why I'm taking this far. But let's say the Supreme Court rules that you broke the law and you're wrong. It doesn't matter. That's not a loss for us. That's still a win because I am fighting for something that I believe in, okay? It doesn't matter if I'm right or wrong by the law. It was illegal for Rosa Parks to sit in the front of the bus. It was illegal to hide Jews during the Holocaust.
Parks was fighting against segregation and discrimination. She was fighting because of voter suppression, separate schools, different waiting rooms, and her inability to hold public office or serve on juries, all because of the color of her goddamn skin. In Nazi-owned territories, it was illegal to hide Jewish people from an actual tyrannical government just because of their choice of religion. Punishment for hiding Jewish people during this time often led to public executions. You, Denver Metro Audits, are whining that you don't have the right to film on the opposite side of a piece of glass, pretending that's some sort of activism, while comparing that to the atrocities that took place during Jim Crow or the Holocaust, resulting in 6 million Jews being slaughtered. Do fucking better.